right. Well, good morning, everyone, and welcome to the Leadership Institute's April virtual Wednesday Wake Up Club breakfast. For those of you who don't know me, I'm Deirdre Hackelman. I'm the Director of Events for the Leadership Institute, and I'm typically behind the scenes running these breakfasts, but today I'll be hosting it virtually. I encourage you to live tweet today's event using the hashtag WWCB. Also, should you have any questions for our speaker during his talk, please use the chat function to submit a question, and we'll try to get to it during the Q&A section. Now, for simplicity's sake, I am the sole host today, but I do have a brief message from our president, Morton Blackwell, and I'll go ahead and read that now. And I won't be doing a Louisiana accent, so bear with me. We certainly do live in interesting times. No need to explain that today. Your Leadership Institute has considerable successful experience with online programming, so it was not difficult for us to convert this Wednesday Wake Up Club breakfast from in-person to online. The big difference is that this morning, we'll all have to fend for ourselves regarding our own breakfasts. And today you're in for a treat. Our featured speaker, Mike Farris, is a special hero of mine. He's one of America's most brilliant, principled, and effective conservative organizational entrepreneurs. Now, you may be interested. I'm going to go ahead and share my screen here. Morton says, you may be interested in this photo taken last Saturday morning of our Leadership Institute building. You see widely separated people lined up on the sidewalk all around the building. They were waiting in line to shop at our next door neighbor, a Trader Joe's grocery store. He says it won't be easy, but our country will survive this current crisis. Americans always pull together in a crisis. Our greatest current problem may be to prevent the left from using the coronavirus pandemic to grow and further centralize big government and permanently damage liberties that made our America free, strong, and prosperous. Signed, Morton. So, now that we've heard from Morton, I will just go through a few short announcements. In 2020, the Leadership Institute has trained 1,123 students in 46 trainings. And since 1979, your Leadership Institute has trained 223,781 students. I've put in the chat a link to LI's upcoming online trainings. Please take a moment to review the schools and consider attending one or sending a friend to a training. We're all kind of cooped up right now, so this is the time to do all the learning that we can. The ability to pivot so seamlessly onto online trainings is made possible only because of the continuous and genuine support of our donors. And again, if you have any questions for our speaker, please submit them using the chat function. And I'm going to go ahead and introduce our speaker now. So Michael P. Farris is President, CEO, and General Counsel of Alliance Defending Freedom. As the second CEO of ADF, he brings to the role a diverse background as an effective litigator, educator, public advocate, and communicator, and was widely recognized for his successful work on both the national and international stage. Farris was founding president of both the Homeschool Legal Defense Association and Patrick Henry College, and continues to serve as chairman of the board of the association and chancellor emeritus of the college. He graduated from Western Washington State College, magna cum laude, with a bachelor's degree in political science, followed by a Juris Doctor from Gonzaga University with honors. He also earned an LLM in public international law, also with honors, from the University of London. Farris has specialized in constitutional appellate litigation. In that capacity, he has argued before the appellate courts of 13 states, 8 federal circuit courts of appeal, and the U.S. Supreme Court, where in 2018, he successfully argued NIFLA versus Becerra, resulting in a free speech victory for California's pro-life pregnancy centers. Farris has testified many times before both the House and Senate. He was an executive committee member for the Coalition for the Free Exercise of Religion that successfully lobbied Congress for the passage of the Religious Freedom Restoration Act of 1993. He also has substantial experience in international religious freedom advocacy. Farris is the author of more than 15 books, as well as a law review and other scholarly and popular articles. He and his wife, Vicky, have 10 children and 22 grandchildren. Well, that's quite the introduction. So without further ado, I'm gonna go ahead and unmute him. And Michael Farris, the floor is yours.
Well, Deidre, thank you so much. It is good to be with all of you. Hang on a second, I gotta hit the button there to start my video. I hope all of you are enjoying your breakfast. I had a nice bowl of oatmeal, as I do every day, and we appreciate it. And Deidre, I would just say that resume is about 2 weeks, 3 weeks old, and we now have 25 grandchildren. So it's a good start. Well, we're here today to talk about the case that is has been argued and is pending for decision in the Supreme Court of the United States concerning June Medical Services versus Russo, which was heard in oral argument several weeks ago now. And the case, ADF played a role in the case. We wrote an amicus brief for the Louisiana legislators that wrote the law, and we substantially helped the Louisiana Solicitor General in the case in terms of helping to prepare her for oral argument, doing moot courts for her and other things. And so we were not the party of record this time because it's a state's case, but we were involved in a substantial supporting way. The case was about unsafe abortion practices. And to give you an example of that, there was one woman's very tragic situation that was highlighted for the court. A woman named Brenda went to a Louisiana abortion facility for a surgical abortion. The doctor perforated the woman's uterus during the procedure and left her lying on the operating table for nearly 8 hours. And then, when she still was in serious situation, rather than calling 911 or an ambulance, he told a staff member to take Brenda to the hospital in the staff member's car and to conceal that she had an abortion. Much later, the hospital staff discovered the skull of Brenda's baby within her uterus and had a tear in it, and that had become infected. And so they had to perform an emergency hysterectomy to save Brenda's life. And of course, as a result of all of that and the negligence and incompetence of the abortion doctor, Brenda is now infertile. And so what this law did was to require admitting privileges for doctors who perform abortions, hospital admitting privileges of a nearby hospital, so that there are multiple reasons, all dealing with safety of the women who are the patients and I believe victims of the abortionist practice. The laws were there to ensure that the doctors were of the caliber that could do these procedures safely. It was all about safety. Had wide bipartisan support in the Louisiana legislature, and a Democrat woman legislator was the chief advocate for this law in many public settings, and was a chief sponsor in many settings as well. And so the case fundamentally was about unsafe abortion practices and a law to deal with that. The case evolved into a really pitched battle over a side procedural issue that is actually very important, and that is called third-party standing. And that is, can abortion doctors represent the interests of women in these kinds of cases? And so when Planned Parenthood sues, as they've done recently to stop Texas from regulating under the um, coronavirus restrictions, stopping abortion procedures as elective surgeries, as all other elective surgeries are being uh, put on hold during this time. Um, Texas is doing that. Planned Parenthood, the abortionists, are suing, and so the question is whether or not third parties can sue under and claim the rights of women, the fundamental right of women to have an abortion under Roe versus Wade. Of course, I don't agree that that is such a right, but that's, I'm not on the Supreme Court, and so the Supreme Court contends that women have this right. But the question is, who can protect the right? Do women have to sue, or can the doctors sue? And so, after many years of this law being in place, not one woman has ever sued in Louisiana claiming this law violates her rights, because the women know that having a doctor who has the competence and the safety record to justify being admitted to a hospital practice is in her interest. And so, even if it's not in the baby's interest, it's at least in the woman's interest to require that. So, if the Supreme Court holds that abortion doctors don't have standing to bring this case, it will put a substantial limitation on many of the abortion cases that you see filed over the years. And the difficulty of finding women who are in these situations shows that they're really not aligned with the women's interests. They claim that they're standing for the woman's right to have this practice, but really it's the right of the doctors and the ability of the abortion industry to make money that's really at stake. So those of you that follow these kind of things closely know that there was a Texas law that was fairly similar that the Supreme Court overturned in the Whole Women's Health case not that long ago. And so the question is, how is this case different than Whole Women's Health, where the Supreme Court did not allow an admitted privileges law? And the answer is the record. In oral argument, Texas could not name a single woman who would have been helped by the act. Well, Louisiana did its homework, knowing that that was a standard that the Supreme Court was going to rely on, and built a substantial record. Brenda's case and many others are included in the record in both the court filings and in the public record that the court had access to, in public documents that were available to the court on the internet. And so the record is a very important thing in litigation generally, but in this case in particular, the state of Louisiana can and did make a very compelling case that the safety record of Louisiana abortionists was horrible, and that they needed to be regulated, and that this was justified fully by the facts that were happening. So the third question that might arise is, will this case reverse Roe versus Wade? I know pro-lifers in general are very anxious to see that Roe is reversed. I'm one of those people that want to see Roe reversed at the earliest possible moment. Later today would be a little too late for me. I mean, I want it reversed as soon as possible. And in the abstract, the Supreme Court can reverse the decision of Roe versus Wade and Planned Parenthood versus Casey and the other supporting cases, can reverse that at any time they have an abortion case in front of them. So in at least abstract theory, this case could be used to reverse Roe. No one in the pro-life legal community expects that to happen. We expect most likely a decision on the third-party standing issue, potentially on the merits of the legislation itself and whether the safety record of Louisiana justifies the law. And both of those things would be good things if the court upholds either or both of those principles. But no one's expecting this case to be the vehicle where the court takes a a review of Roe versus Wade itself. That's not been briefed and really argued by the leading parties. I think there were some amicus briefs to that effect. Cases like this attract a lot of amicus briefs, some of which are not as likely to get the court's attention as others. But it begs the question, what's it going to take to reverse Roe versus Wade? And I'll tell you the general view of most pro-life litigators. We believe that Chief Justice Roberts is the key to reversing Roe versus Wade. And we believe that his vote is attainable in that regard. But he has a practice of wanting to go in deliberate steps and not take big bites all at once. And that if there's an intermediate step that undermines Roe without completely reversing it, and he votes in favor of that, then a second case could be brought that would be, he could then rely on the first case saying, well, Roe's already been undermined, therefore we should reconsider it, and now we'll reverse. We believe that that's a plausible scenario. There are 3 votes on the court that are really pretty clear, that ready to reverse Roe from what they've written in prior opinions. Justice Thomas especially is clear that he's ready to reverse Roe. But both Justice Kennedy and Justice Kavanaugh are perceived as being the key people in this analysis. And so the kind of case that we think is the most likely is a eugenics type of law. Even though the court turned down the Seventh Circuit case from Indiana, where it banned sex selection abortion on the account of race, and other reasons for eugenics kind of prohibitions, the court denied cert in that case. Not to anybody's great happiness, but the court tends to want to have a split in the circuits, meaning 2 or more federal circuits have considered the issue and have gone different ways on the issue. And so there is litigation ongoing right now that would bring, and we're looking for more cases, that would bring this up in a direct way, so that Missouri has a law that's similar to this, and that's in litigation. If that case gets a good decision from the 8th Circuit, where Missouri is located, then we have a split in the circuits, and then we have a shot at getting the court to ban abortion in a pre-viability context for any reason at all. So if the court says you can't use your right to an abortion to kill babies because of their gender or their race, that would be a very helpful interim precedent that could then lead to a reversal of Roe by taking up a heartbeat law, or a law that just simply reinstitutes the pre-Roe standard of the right to life is protected. And so that's what we believe it will take to reverse Roe versus Wade. And I really believe that within 2 to 3 years, there is a realistic chance that we'll have a case before the Supreme Court of the United States where there's a viable opportunity to reverse Roe. So what's going to happen in this case, in the Louisiana case that the court has in front of it right now? Obviously no one knows for sure, but the pro-life legal community feels really pretty good about the chances to win on the third party standing. So we'll see. Certainly by June 30th. Well, with the COVID-19 going on, nobody knows how that's going to affect the court's docket. Normally, everything is released by June 30th, and so and since this case has been argued in advance, well, far enough in advance that that's possible. I think we will see it by June 30th, and we hope for a positive decision, at least on the third-party standing issue. The impact of the precedent will, as I alluded to earlier, will clearly limit the ability of abortionists to challenge laws that are there for the protection of women and for protection of babies, and that they're going to, if a woman's right to an abortion is going to be the context, then a woman is going to have to be the one that litigates it, not Planned Parenthood or some other abortion profiteer. And the case that's going on right now, Planned Parenthood sued on the COVID restriction, and the Fifth Circuit yesterday stayed a decision from a Texas district court that held gave a temporary injunction, temporary restraining order to Planned Parenthood in favor of Planned Parenthood, allowing them to keep killing babies during the COVID-19 quarantine. But the Fifth Circuit stayed that yesterday on an emergency basis and demanded very, very quick briefing from both the parties. And so I expect a decision within a week for sure from the Fifth Circuit on whether or not there's going to be a stay during the litigation under that law. But that's the kind of case that the standing issue will impact. And so it will have a real potential impact. So with that, that's kind of my analysis of what's going on. And I'd be glad to take any questions. Deidre, is anyone giving us any questions to talk about?
Okay, so I do have a few questions for you, and I'm going to use my moderator privilege here to ask one first. Let's see, so first off, I would like to know, working at LI and doing activism, how can activists like those who are trained here at LI assist ADF and other organizations that fight on the legal side of civil liberty issues?
Well, there are three main fields of conflict on these cases. There's the courts.
And we can't hear you, Mike. Did anything change on your end?
I didn't touch anything, so.
Okay.
Okay. I got I'm getting notes that people can say that they can hear me.
Okay, great.
Okay. Okay, so there are three real arenas of conflict, battle, action on this. One is the court, and I know that many LI grads end up going to law school, and they can help in a variety of ways. Passing legislation, getting the right kind of legislation through is always important in these cases to set the cases up. And so many LI grads work many are legislators, many are legislative staff, and many work for advocacy organizations in the various states, and some in Congress as well. This is going to be mostly a state-based battle in the ability to reverse Roe. And so working in and around the legislative process is always important. And the third, and where all the LI grads can participate, is the court of public opinion. And so keeping these issues in front of people and making the arguments in op-eds, in blogs, in social media contexts, it matters. For example, Alliance Defending Freedom argued the Masterpiece Cake Shop case. And we believe we won that case because of one sentence that was repeated over and over and over again in public and in the court proceeding. And that is, Jack Phillips serves all people. He's not willing to deliver all messages. If the Supreme Court thought that Jack wouldn't serve gay people at all, we didn't feel very good about our chances in that case. And so the fact that we were able to get that public message across. And so understanding, in this case, for example, the message that this is about safety for women, and abortion doctors shouldn't have the ability to stop a safety law that's designed to protect women any more than Ford Motor Company should be able to stop a safety law claiming that they're protecting the rights of passengers. The passengers need to speak for themselves. The women need to speak for themselves. And so that kind of messaging is very, very important. So those are some of the ways that LI grads could help, among others.
Okay, great. We do have a couple of questions that people asked ahead of time. We have one says, I would like to hear Mike's opinion on the constitutionality of various governors' stay-at-home orders forbidding church meetings, etc.
Well, we are actively looking at many of these issues, and we've had to send a few letters in this case, or in cases like this. The first thing to be noted is that no right, including the free exercise of religion, is considered absolute. And so to say that the government can never stop church services is going too far, because under the right kind of circumstances, that is possible. So, for example, if there's been an earthquake and a church structure is damaged and it's unsafe, the government could readily, and would be upheld, say that you can't use your church building for church services until you get the earthquake damage fixed. And so, just to use an example, that it is possible for the government in the right kind of context. So the real issue that we're looking at and have written demand letters on in several contexts is when churches are being treated unequally. When the first round of the governor's orders in Washington State allowed business meetings of any size to proceed, but churches were banned. And so we thought that was problematic, and we're ready to go on. In fact, we were getting ready to sue on that when the governor then banned all meetings of any kind. And so if there's unequal treatment for churches, that's a real problem. And the standard for churches, it should be, can the government make the showing that the goal that they're pursuing is of the utmost importance? And I think that courts would listen carefully to the argument that stopping a pandemic satisfies that compelling interest test. But the question is always going to boil down to, in at least most of the cases, whether or not they've chosen the least restrictive means. And so that's going to be case by case, order by order. There are some contexts that the courts would probably uphold many of these, but there are others, depending on the facts, where they won't. And so we're looking at them. We're about to file litigation on a related thing where the mayor of Greensboro, North Carolina, is stopping abortion protests outside. They allow the abortion proceedings to go forward, but people who are outside praying in front of the abortion clinic are being arrested, supposedly for violating the social distancing rules, even though they've followed them meticulously, the number of people coming and distancing 6 feet and all of that. And so it's a pretext. And so when these laws are used as a pretext for stopping either freedom of speech or freedom of religion, we're going to be looking at those things.
Okay. Next question is, what do you predict will change in the homeschooling world as a result of so many parents staying home with their children during this quarantine?
Well, that is very interesting. I wrote a thing on Facebook about, giving people a synopsis of things they could do with their kids and how to homeschool their kids, and it took off. Normally, if I just on my personal page write something, a good one, 15, 20,000 people read it. This one got close to 200,000 people reading it. So a lot of people like my advice. So the one thing I think will happen is that at least some people will say, hey, this is pretty good. We'd like to continue homeschooling. But I think pretty much all of America now thinks that homeschooling is an acceptable alternative. And so our legal rights to homeschool as a movement, those who want to homeschool, I think has been improved dramatically by the fact that it's now, the government every place was telling you, you guys should stay home and homeschool your kids. And when they didn't say just, keep your kids at home and don't do anything with them, they'll be okay. They said you should homeschool. And so the fact that virtually all Americans now believe that the government recognizes that homeschooling is a viable alternative, I think that says good things about homeschool legal rights, because there is a movement to try to curtail those rights. There's a planned conference at Harvard in June, whether they have it still or not, I don't know, but of enemies of homeschooling who are trying to curtail the right to homeschool. And the reason they're trying to curtail the right to homeschool is they don't like the fact that homeschoolers successfully teach their kids in an environment where the government's not required and the government thinking is not required. And they don't like that independence of thought. And so I think that conference and its efforts are going to fall on its face in light of millions and millions of kids now being homeschooled, and people think this is normal, this is okay.
Great. So what was your most rewarding case that you worked on internationally?
Wow. It's probably the German homeschool family, although there's one that's pending right now that I had a limited role in that will be even more rewarding perhaps, but I'll tell you about both of them. I helped on the case, the Wunderlich family from Germany. I was in their home shortly after the events that I'll now describe, where they wanted to homeschool. The government in Germany said they couldn't, and they sent multiple cars of armed deputies and stormed the house, took the kids away. When the mom tried to kiss one of the girls goodbye, the police officer said it's too late for that and snatched the little girl away. And so this family litigated against Germany to try to continue to have the right to homeschool. They were unsuccessful in that litigation, all the way to the European Court of Human Rights that upheld the German protocol. Nonetheless, the family went back and recently won a lower court victory for themselves on a reconsideration, and they've continued to homeschool. And now all of Germany is homeschooling, and we're told by the government that they need to homeschool. And so even the Germans that were enforcing a Hitler-era law requiring compulsory education, and the reason that they want that law is because they argue that they don't want parallel societies, which means they don't want people who think differently than the German government wants them to think, which is a very Nazi-like argument and a very Nazi-like theory. And so that's incredibly dangerous. But the fact that the Wunderlichs, even through all that, basically were able to homeschool their kids in most of those years was a very gratifying thing. There's a case in India right now that's pending in the Supreme Court of India that my role has been, I've raised money for the case and have encouraged our staff who's arguing. But ADF is helping to argue the case. But so my personal role is backup in that regard. But in that case, the Dalits, which are the so-called untouchables, 300 million people in India, are treated by Hinduism as worse than dirt. There was a Dalit girl whose shadow fell in the path of an upper caste man, and he took his cane and nearly beat this 11 or 12-year-old girl nearly to death. Apparently, it was not okay for her shadow to touch him, but it was okay for his cane to touch her. And so there is a real hunger and receptivity to the gospel among the Dalits, because they get a very different message from Christianity. They say that you're so valuable that the Son of God died for you and wants you to have a relationship directly with God. And so but the law of India has some protections for the Dalits in civil rights context, job rights and other things. And they lose those rights if they leave Hinduism and become a religion of any kind. And that case is pending right now. It was scheduled for oral argument before the Supreme Court of India, but that's going to be delayed because of the whole coronavirus situation. But if we win that case, and we think there's a good shot that we'll win that case, then people believe that something between, well, just millions and millions of Dalits will change their religion. I think most of those to Christianity. I mean, some may become Muslim and Baha'is or other things, but we believe that there'll be a lot of conversions to Christianity if that happens.
That's really powerful stuff. So going back to kind of how you got into things, was there a particular incident or instigating force that caused your lifelong fight for religious freedom?
I was 10 years old, and my dad and I were changing irrigation pipe in eastern Washington. And I guess the start of the story is by the age of 6, I was reading the newspaper every day. And so I was very interested in politics. And so when I was 10, I told my dad that I wanted to get involved in politics. And he said, well, if you want to be in politics, you need to be a lawyer like Mr. Moorbeck over there. He pointed to a lawyer's house across the field. And he said, lawyers make $20,000 a year. And that was like unheard of. I mean, a new Cadillac in that time was $2,000 a year. So just think 10 Cadillacs. That's the means of evaluating what that was about. And my dad was a public school principal, and he didn't like what was being done to the public schools by the ACLU. And I found out at my dad's funeral about 4 years ago why he thought that, because he was reading the Bible to kids, he was praying with kids, he led kids to Christ in his office. And so he was over the top, and he needed legal defense, frankly, what he was doing. But he was using, he was just ministering to kids. And the kids came to his, many of the kids came to his funeral as a result of that. And so it was my dad's influence in showing that what was being done to our country by trying to keep God out was not for the good of people. That got me interested in it, and things kind of went off from there.
Yeah, a lot of us start pretty young. What would you tell a young conservative starting out in the movement? We get, especially at LI, we get a lot of interns coming through who are interested in law. So not everyone can be a lawyer, but what would you say to someone starting out who's interested in taking the legal route in trying to help the movement?
Well, the first thing I would say is study really, really hard and get good grades, and go to a top law school and get on law review, and then clerk for a court. And when you do all that, you should apply to Alliance Defending Freedom to become a Blackstone Fellow. We have a program that's much like LI, but very, very narrow, and that is you have to be in law school when you're doing it. And it's typically for people who've completed their first year of law school. And so we take about 160 students, and they get hired as federal judicial clerks pretty readily. And so if you really want to make an impact in the movement, getting properly credentialed and trained puts you in the best place to be hired to be in the Solicitor General's office of a state, or even the Solicitor General's office of the United States, or an Attorney General's office, or working for a legislator at a high level, or other alternatives. And so studying hard, learning to write very well. It's oral argument's cool. I mean, I coached moot court, and My teams, while I was there, won 12 national championships and one world champion as the coach of Patrick Henry College. So I believe in oral advocacy, but brief writing is actually more important. And so learning to write very, very well is incredibly valuable. So study hard, write well, keep your nose clean, and participate in movement groups, participate in the Federalist Society, participate in Christian Legal Society, participate with Blackstone Fellowship, participate with LI. And judges who you will want to work for will note that you've participated in those kind of ways, and that will be very helpful to you.
Okay. This question might be a little tricky. It's like asking you to choose which is your favorite child, which is particularly difficult for you. You have 10. What promising cases are you working on right now? Or what is your favorite case? What gets you excited to get up in the morning?
Well, the case in India that I've already outlined is my favorite international case, that's for sure. We have pending before the Supreme Court the Barronell-Stutzman case out of Washington State, which is the follow-on to Masterpiece Cake Shop. Barronell is a florist, really in my hometown in Washington State. Her flower shop is in Richland, Washington. My family owns a Christian bookstore in Richland, Washington. Her trial was in Kennewick, Washington. I graduated from Kennewick High School. So to say that its hometown is the understatement of the century. And my mom just had her 90th birthday. I ordered flowers from Barronell's shop to be delivered to my mom. And so her case is pending before the court. And it looks like the court is holding her case for being resolved after the Philadelphia-based case is resolved involving adoption regulations, where whether or not the Catholic Adoption Services have to agree to work on adoption applications for same-sex couples or not, or whether they can simply work on cases where they agree with the faith practices of the people. And so it's a good case, and our case is there with it and is parallel to that. And so I'm hoping that they'll use this case to reverse their very bad decision of Employment Division versus Smith. In the resume, you talked about the Religious Freedom Restoration Act, which I helped to write. And that law was made necessary because of Employment Division. It shouldn't be necessary. We should have the First Amendment straight up as the right to protecting our religious freedom in a robust fashion. And so if that case results in the reversal of Roe versus Wade, or excuse me, of Employment Division versus Smith, that would be my favorite thing of all right now.
Okay. What is an issue or group of issues that you wish conservatives would rally around more effectively? That also may be a difficult one to choose just one. So if you want to choose a few, feel free.
Okay, well, I'll pick one because it's near and dear to my heart. And, the way the question's phrased is would rally around more, because conservatives rally around the right to life, and they should. But that's pretty pronounced, and a lot of people working on that. Religious freedom people understand that and work on it very much. Well, one where I wish we would do a better job is parental rights. The right of parents to direct the upbringing of their children is very important, and we're seeing a lot of conflict now in the transgender area, where parents are losing their ability to control their decisions for their kids. And we have a case going at ADF right now where a Wisconsin school district has a secret transgender program where they treat kids as transgender at school, and the teachers are told to lie to the parents about it and to conceal this from parents. And so we think this is such a profound issue for kids that, at a minimum, parents should be involved. And so the cavalier fashion that government runs over families is very concerning in many contexts. And I would hope that more and more people would pay attention to, the idea of limited government means basically we make our own decisions in our own spheres, and government doesn't make its decisions for us, whether that's economically or any other context. We want to make as many of our decisions as possible. And there's no place that principle needs to be honored very, very scrupulously is in the home, where parents can make decisions for kids, not government make decisions for kids.
Right. We did have one question come in, having a little bit difficult time understanding what their question is. I don't know if you can see it in the chat, Michael, but we have an attendee who's receiving ART treatments and is wondering what we can do better about the cost of fertility treatments, I believe.
That's something that's beyond my expertise. I don't know how to answer that question. So
sure.
I'm very sorry.
No problem. Okay, well, that is the end of our questions. Mike, did you have any closing comments or calls to action for our network here at LI?
Well, first I want to say how much I appreciate LI and Morton. Morton has been my friend and mentor. When I arrived in Washington, D.C. in 1983, two of the people I got to know right away were Morton Blackwell and Paul Wyrick. And even though they're only a little bit older than me, Morton's just, a smidge older than me, maybe 10 or 12 years older than me. But nonetheless, they took me under their wing and showed me the ropes. And so I have a 40-year appreciation for Morton as an individual. And I've participated in lots of LI programs over the years. Before I ran for Lieutenant Governor of Virginia in 1993, I went to a candidate training school that LA put on. And so, and Paul Wyrick was involved as well in a school. So I've benefited from myself and benefit from working with LI trained students over the years. So I have deep appreciation for that. And I would just simply say, I have seen the outsized impact that people who get involved have, and people who have an idea what they're doing and do it faithfully can really work well and work hard. And I would say I guess the best advice I could give people is treat people well over the years. It will matter in the long run. Don't burn bridges with people. Try to be kind to people. I'm dealing with a situation with HHS right now, and a 40-year friend of mine is now a lawyer for HHS. And the fact that there's that friendship and trust for 40 years, we never have had cross words with each other, and that trust, it will matter, and it will matter for the rest of your life. And so if you think some issue is really, really important, okay, that's fine. But treat people well over the years, and it will pay off for you in the long haul. So that would be my advice to young conservatives.
Well, thank you so much, Dr. Farris, for sharing your thoughts with us this morning. That was a real treat. You can, sorry?
You're welcome. Thank you.
And please expect an Adam Smith tie in the mail. I unfortunately don't have one to show everyone, but we give those to all of our speakers.
Thank you.
All right. So thank you to everyone else who tuned in. I'm so glad we could continue this event from the comfort of our own homes. I hope you cooked up some bacon and had some grits if you're so inclined. And join us May 6th for our next Wednesday Wake Up Club breakfast. It's with attorney Mark Paoletta. He's the general counsel of the Office of Management and Budget. And I encourage you to RSVP online at leadershipinstitute.org/breakfast. And again, consider taking one of our online trainings at leadershipinstitute.org/training. Until next time, take care and stay well, everyone.
Thanks so much for watching this video. To watch our latest video, click here. And to make sure you don't miss any future videos, be sure to subscribe.